The Federal Acquisition Regulation states that no person or other entity may disclose contractor, bid, or proposal information or source selection information to any person other than a person authorized in accordance with applicable agency regulations or procedures by the agency head or the contracting officer to receive such information. Contractor bid or proposal information and source selection information must be protected from unauthorized disclosure. Individuals that are unsure if particular information is source selection information are required to consult with agency officials as necessary. Individuals responsible for preparing material that may be source selection information must mark the cover page and each page that the individual believes contains source selection information with the legend Source Selection Information, see FAR 2.101 and 3.104. In the matter of Dell Services Federal Government, the protester filed a challenge alleging that one of its competitors had received copies of some of its proposals. The Procurement Integrity provisions of the Office of Federal Procurement Policy Act, known as the Procurement Integrity Act, provide, among other things, that except as provided by law, a person shall not knowingly obtain contractor bid or proposal information or source selection information before the award of a federal agency procurement contract to which the information relates. The Federal Acquisition Regulation states that a contracting officer who receives or obtains information of a violation or possible violation of the Procurement Integrity Act must determine if the reported violation or possible violation has any impact on the pending award or selection of the contractor. If the contracting officer determines that there is no impact on the procurement, he or she must forward the information concerning the violation or possible violation, along with documentation supporting the determination that there is no impact on the procurement, to an individual designated in accordance with agency procedures. If that individual agrees with the contracting officer's analysis, the procurement may proceed. If the individual does not agree, the individual must forward this information to the head contracting authority and advise the contracting officer not to proceed with the award. In this case, the contracting officer prepared the appropriate paperwork, and the documents were reviewed by and concurred with by both the agency's designated individual along with the head contracting authority. At the procurement level, the government investigated the issue and determined that it would not have any effect or impact in connection with the procurement at issue. When the matter came before the GAO determined that there was a possible impact in connection with the procurement and that the agency had failed to take several material considerations into account. The GAO also noted that there was the potential for an unequal access to information issue and/or biased ground rules, resulting in an organizational conflict of interest. The GAO sustained the protest on this issue as well because the record showed that the firm at issue had access to non-public, competitively useful information, and that the individual supplying that information may have participated in developing the agency requirements for the current solicitation. The GAO found that the agency neither meaningfully evaluated whether an organizational conflict of interest existed, nor took any actions to avoid, neutralize, or mitigate any such potential conflict.